Okay, well, I believe we are finally live again. So thank you everyone for joining us. Welcome to our employment law session. My name is Lior Samfiru. I'm the employment lawyer, and I am here to talk about employment law. I'm here to talk about one of the most important things now and always, which is your rights in the workplace. We are live here. This is a live session. I'm live to take your questions about employment law right now. So take advantage of that. Take advantage. You have one of the top employment lawyers in the country. I know I'm saying so myself, but it's true. Answering your questions. So ask questions. Post them right now. Let's talk about your workplace rights. Sometimes things go great at work, which is great, but that's not always the case. Sometimes problems arise. We're not sure how to respond when the boss complains about us. Maybe we've been given an ultimatum. You have to sign this document by Friday. Maybe we've been put on a layoff. Maybe we've lost our job. Maybe we've been disciplined, suspended, given a warning. Whatever that issue is, it's going to cause stress. Well, I'm here to try to solve that problem. I'm here to try to make it better and give you the ammunition you need to have to understand your rights, to respond to these issues, to do something about your workplace problems. And I do that because the law is actually quite good. Employment law is quite extensive, quite comprehensive, and it's very, very good for employees. A lot of people simply don't understand what it is. So that's why we have this session. That's why we're here. That's why I'm here answering your questions. Now, if you want to learn a lot more about employment law, about your rights, first place you go to employmentlawyer.ca. Again, employmentlawyer.ca. That's my law firm's website. You will see that a lot of information there. You'll see questions, answers, fact scenarios, all kinds of knowledge that you can get from that website. But the other thing you can get on that website is my contact information, phone number, email address, fax number, not just for me, for my entire team. So if you want to connect with me off social media, off these sessions, you want to have a private discussion, easy. I want you to. I encourage you to do that. All you have to do is go to employmentlawyer.ca, again, employmentlawyer.ca, and you can connect with me that way anytime. I'm available, not going anywhere, happy to answer your questions. But right now, we are live. You're watching me, I'm sitting here, we are live, wanting to talk to you about your workplace rights. This is a live Q&A session, so let's talk about workplace rights. Let's talk about things you need to know. As we're waiting for your questions, I want to talk about something specific here in Ontario. Very important that we all understand this. So in Ontario, the government of Ontario has implemented the infectious disease emergency leave. Sometimes we call this the COVID layoff. What that means is that an employer puts the employee off on a leave and they don't have to call them back for a period of time. Now that period of time was supposed to end on July the 3rd, so in a couple of weeks. So many employees were expecting by July the 3rd to hear back from their employer. Say, well, tell me now, what's happening. Unfortunately, that period of time has now been extended again, all the way until September 25, okay, September the 25th. So because of that, if you were waiting and expecting to hear back from your employer in the next couple of weeks, that may not happen. That won't happen until the end of September unless it gets extended again, which it could have. So for many people, that's very frustrating. You've been off work for months and months. You were thinking, okay, now is the time. Enough. Now I'm going to hear from my employer. Now I'm not going to hear it's been extended. Well, don't actually worry about it. There's the other option. You can choose now, if you want, to treat your employment as being terminated. You do not have to wait until September the 25th. You can make the decision now to treat this layoff, the infectious disease emergency leave, as a termination of your employment. In other words, instead of waiting for your employer to decide, you can decide now, if you want, that enough is enough. I've waited long enough. I'm not waiting anymore. And instead, I want my severance now. If you want to do that, give me a call. We'll make it happen. I'll help you do it. We've done it for literally thousands of people over the past year. So you can do that now if you want. I know that this is very frustrating. You don't have to wait until September the 25th. If you wait until then, that could get extended again. It's already been extended 4 times. So if you've been put on an infectious disease emergency leave or a layoff, You don't have to accept it. You don't have to wait till September. You don't have to wait till July, till August. You can decide right now that enough is enough. Okay, very important. So if you're in that situation, you know what to do. Otherwise, hey, we're live right now. I'm live, you're live. Employment law, workplace rights, harassment, human rights, bullying, termination, wrongful dismissal, whatever that issue is, now is the question. Don't be bashful. You'll be helping yourself. You'll be helping others ask that question. So bring it on. We'll start now answering questions. Ask yours too. First question comes from Facebook. This one is from Kevin. My employer wants to change the duties of my job. I know they cannot do this. Do I always need to demand my severance, or can it be worked out with the employer? I am disabled and I fear I cannot find another job. So the first question, Kevin, is what kind of changes they're making. If they're very minor changes, very minor, they may be able to do that. If there's significant changes, then they don't have a right to do it. So here's what your options are. If you don't want to accept it, you can tell your employer, I'm not doing it. And if you're going to make me, then I want my severance. If they pay you your proper severance, that's great. Realistically, they're not going to do that. We will have to push that issue. We will have to pursue this as a constructive dismissal. It's extremely rare where the company says, okay, no problem, employee, here's your severance. We would need to get involved. So if you've asked for your severance and your employer won't pay it, then let's deal with that. Let's get you that severance that you're owed. Okay, and if you are disabled and if because of that it's going to be more difficult to find another job, you're going to be owed even more severance than you would have if you were not disabled. Okay, because it's going to take you longer to find another job, you're owed even more severance than usual. So yes, certainly try to resolve this with your employer. That's always the best option. But if your employer is going to insist on these changes, if they don't care, they want to do them, then your option at that point is to say, enough, that's a constructive dismissal. Kevin, if you want to have a chat privately, if you want me to help you get what you're owed or deal with your employer, not a problem. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. You see that right here on the screen. Contact me through there. Phone number is there, email address. Happy to chat with you. Thank you for that question, Kevin. A very good question. I'll continue answering questions. Ask yours as well. You have plenty of time. Let's answer as many questions as we can during this session. Another question from Facebook. This one is from Jessica. Can my employer, who runs a privately owned business, administer a rapid COVID test himself or bring in a nurse to administer the tests? Are we required to take these tests in the workplace, or can we refuse? My employer is also asking me weekly if I have a vaccine booked. So let's start with the last portion of this, Jessica. And your employer cannot demand a vaccine, and frankly, they shouldn't even be asking if you have been vaccinated. Your employer has to comply with what the government and the health authorities say are the regulations in the workplace. And there are for most employers, there are no regulations saying that you have to have your employees be vaccinated. So that's that. And in terms of tests, those should be administered by professionals. I'm going to say right now that it's okay for an employer to demand regular rapid tests, given the nature of the pandemic. Once COVID is not really an issue, once the numbers are even more under control, once we don't really have concerns anymore about people catching COVID-19, no, that would be overstretching it. But right now, an employer can, I would say, demand regular tests as a way to protect the workplace. That's reasonable, but they certainly have to be administered by professionals, not just by some random person. So you can refuse if they're not administered by a professional. You also can tell your employer, don't ask me anymore about vaccines. I'm not answering that anymore. You can't be punished for that. If they do, come talk to me. Reach out to me through employmentlawyer.ca. But I've been getting that vaccine question and in fact, the rapid test question very often over the past few weeks. So hopefully that helps shed some light on the situation, Jessica. Happy to have a follow-up discussion with you. If you want to, just reach out to me through employmentlawyer.ca. Waiting for more questions, guys. Ask those questions. One thing I did want to mention is this. We've been having so many people contact us that lost their jobs that we've implemented an across-the-board policy across all our offices in Ontario, BC, and Alberta that we're going to do completely free consultations for people that have lost their jobs. These are difficult situations. I know people are struggling with this. So if you lost your job, we're going to not charge you anything. We're going to do free consultations completely. No strings attached. We want to help people as much as possible. So tell others as well. Okay, if your friend, your neighbor lost their job, whether it's because of COVID-19 or not, whether it's because something they did or because of the company's business decision. If they lost their job, have them chat with us. We're going to not charge anything. I want to help as many people as possible. I really, truly believe that everyone has a right to know their legal rights. So now's the time to do that. And you or your friends can reach out to us through employmentlawyer.ca. So keep that in mind. Now, as we're waiting for our next question, again, don't be bashful. You're watching, may as well ask questions. Let me answer a couple of common questions that I've been getting. One common question that I've been getting is, can my employer change my job or hours of work because of COVID-19? A lot of employers are saying, well, it's COVID-19 now where the business is operating differently, so we have to give you different hours or a completely different job. So let's be very clear. Even if it's because of COVID-19, even if it's for legitimate reasons, an employer still does not have the right to change your job in a significant way. So they can't move you from mornings to afternoons. They can't tell you that you're going to work night shifts instead of day shift. They can't demote you or take away your responsibilities. They can't change your pay in a significant way, more than a few percentage points. If they do that, if your employer does that, it's still a constructive dismissal. So COVID-19 has not eliminated this concept of constructive dismissal. Even if the change is done in good faith, I'm not suggesting your employer is trying to pick on you or to hurt you. Even if the change is done in good faith, the change to your job, to your pay, to your hours, it's still not allowed. You can still say that's a constructive dismissal. You can still say, I'm not accepting this. And if your employer implements it, you have options, you have legal recourse, they'll have to pay you. So that's something I want you to remember, that a lot of people think, well, it's COVID-19, so clearly my employer is allowed to do something because it's such a unique situation. No, your job is still your job. Your pay is still your pay. Your hours are still your hours. And your employer can't just decide to change that at will. So an important thing for you to remember. Hopefully that helps clarify some of the questions that you may have on that issue. But other questions, I know you have them. I know there's issues that are unique to you or things that have come up in the last number of days or weeks. Ask. Don't be bashful. Post your question. You can write it right now on the screen. I'll see it. I'll read it. I'll answer it. And you can walk away with all the information you need to have in that regard. So don't hesitate to ever do that. And as we're waiting for the next question, again, I'll talk about some other common questions that I'm getting. And this one, of course, very common. I said we've been contacted by a lot of people that lost their jobs. Well, a question that I get very often is, can my employer avoid paying me severance if the business is suffering because of COVID-19? So business may be not doing so well. Employer lets the employee go. Can the employer say, well, it's not our fault, it's COVID-19's fault, so we don't have to pay you severance, or maybe we don't have to pay you as much severance? No. Your employer still has to pay you your full severance package, even if it's because of COVID-19, but I'll go a step further. Not only do they still have to pay severance, you may get even more severance during COVID-19 because it's potentially more difficult to find a job now than it was before COVID-19 hit. There's less jobs out there. There's more people looking for work. So that may mean it's going to take you longer to find another job. That means more severance. So regardless of how the COVID-19 has impacted the employer, from a legal standpoint, your employer still has to pay you your full severance, which can be as much as 24 months pay, 24 months. If you want to know how much severance you're owed now, easy. Just go to pocketemploymentlawyer.ca, pocketemploymentlawyer.ca. Use our severance calculator tool. Takes you 10 seconds flat, free, anonymous. Find out how much you're actually owed. You, your friends, your relatives. Check it out at pocketemploymentlawyer.ca. I'm going to continue answering questions right now. Great questions always coming in. Ask yours too. Another question from Facebook from BC Pinoy. I'm employed in a big company. I made a special arrangement with regards to my schedule due to no available childcare in my area. However, after 1 month, my supervisor said enough is enough. They will no longer accommodate my request. What should I do? Well, your employer does have to accommodate your request. We call this accommodation based on family status. If you have a child care need, and the only way you can meet that need is through help and accommodation from your employer has to accommodate. They can't say, well, we've accommodated you for a month, now it's your problem. Now, that said, you do have an obligation to try to make other child care arrangements and do whatever you can. But if you've made those efforts and you cannot find childcare, then your employer still has to accommodate you. They can't say we don't want to. They can't say it's your problem. No, it becomes the employer's problem. So yes, make childcare arrangements. Tell your employer that you have and that you're continuing to look. And if your employer won't accommodate you, let me know. Sometimes a quick letter from me, the employer realizes their mistake, they back off, and all is well. So happy to chat with you, but yes, your employer still has to accommodate you. Excellent question. I've been getting that question very often. So hopefully, BC Pinoy, that sheds some light on your situation. See how easy it is? Question asked, question answered. Do the same as well. Next question from Corinne on Facebook. Can you still pursue a better severance if you were let go 9 months ago and have only applied for a handful of jobs due to no comparable job openings in my area? Absolutely you can, and you must, unless, of course, Corinne, you've already signed off on that severance. So, for example, if the company said, we're offering you this amount, but you have to accept it by signing this document. If you signed the document, then you gave up your rights. But if you didn't sign anything, you absolutely can pursue it. Doesn't matter whether you did a good job looking for work or not so good a job. Yes, you can. Now, Corinne, if you want me to tell you right now how much severance you're actually owed, I could do that very easily. Just tell me how long you worked for the company, how old you are, and what kind of a job you had. And I can tell you whether you're owed 2 months, 12 months, 24 months. So your age, your position, and the length of your employment. But you should pursue it, Corinne, unless, of course, you signed off on it already. So hopefully that helps. Ask a follow-up question, though, Corinne. I'm here, happy to answer. You have time, everyone. Ask questions. Next question from YouTube from Jackie. A friend of mine in Ontario has a job working from home for an American company. If she happens to lose her job, do they have to follow Canadian law regarding severance and holiday pay? Absolutely yes. Great question, very important one. If your friend physically works in Ontario, then Ontario laws apply. Severance, holiday pay, overtime, all those rules apply if they work in Ontario. Now that's important because in the US, they have very different employment laws that are not anywhere as good as in Canada. So you don't want US laws to apply to you, you want Canadian laws to apply to you. So for your friend, absolutely, it's Ontario laws if your friend works in Ontario. If anything happens with your friend, okay, certainly if your friend loses her job, have your friend call me, okay? We'll do a free consultation. We're doing our free consultations for anyone losing their job. We've had so many people contact us when they lost their job. We want to help and advise as many people as possible. So if you or someone you know lost your jobs, an opportunity to get a consultation with us, some of the top employment lawyers in Canada, free, no charge, just to help you so you understand what your rights are. Great question as always. So next question comes from Linda. My work is demanding an exemption note from my doctor re-COVID. My own doctor denied me, but I found an MD in BC who is willing to give me one. Can they decline that? Well, Linda, they're actually not allowed to ask for an exemption letter at all, okay? There's no legal right that they have to say, well, you can refuse only if you have an exemption. No, the only way they could do that is if the government says they have to do that. Otherwise, they can't decide that. So the question is not can they refuse the note, the question is they shouldn't be doing it, or the issue is that they shouldn't be demanding that to begin with. So Linda, if you want to kind of cooperate, yes, get that note from that doctor, that's fine. But keep in mind, they're actually not supposed to be asking for that anyway. You can decide if you want, for your own reasons, whether to be vaccinated or not. All right? Any issues, any problems, any threats by your employer, reach out to me, okay? Not months later, reach out to me as soon as that happens through employmentlawyer.ca, employmentlawyer.ca. Contact me right there. Let's see. Corinne has a follow-up. I didn't sign that severance offer. The offer an acceptable amount, almost 9 years, 2 years old. So you haven't told me yet, Linda, what kind of a job you had. Depending on the job, you'd be owed anywhere from 9 to 12 months likely of severance. If you're in a more senior role, it could be as much as 12 months. So unless you've been offered that, Linda, you know that's wrong. I wish you hadn't waited 9 months, because we could have already gotten you the severance months ago, but that's okay. No big deal. Reach out to me now. We should be able to resolve this in a few weeks and get you the severance that you're owed. Again, we're going to do a free consultation here, so reach out to me through employmentlawyer.ca. All right. Oh, you're a junior interior designer and marketing manager. So yeah, you're probably owed, right around 10 months pay, 9 to 10 months pay. So unless that's what you've been offered, Corinne, then you know what to do. Reach out to me. Don't wait another 9 months. Please do not wait. At some point, you're going to run out of time. There's no point doing that. It's money you're legally owed. Why let the company hold on to this money? You should have money you're legally owed. Okay, so reach out to me. Let's see. Next question. Gospel Intel says, is settling and mediation much better than taking it further? Well, if you can get it's always better to resolve a matter, right? So if you can get a good resolution and mediation, that's always better, right? Sometimes as a part of a settlement, you could do much better than you would get anywhere else, better than court, better than tribunal. So absolutely. So Linda says, when I called, I got a lawyer within your firm. I want to speak. You want to speak with me? That's fine, Linda. Just say you want to speak with me, but keep in mind, every lawyer on my team, every lawyer, we have 34 lawyers across the 3 provinces, some of the best employment lawyers in the country. Okay, you're in amazing hands, whether you speak with me or any one of the lawyers on my team. So we got you. We got your back on this. If you want to speak to me, that's absolutely fine. But you don't have to worry about that and stress out over that. If I'm not available for the next week and one of my colleagues can talk to you tomorrow, that's better. You don't want to wait a week. But that said, not a problem. Either way, call us. You see the number on the screen right here, or just go to employmentlawyer.ca. Let's see. Okay, from John Michael on Facebook. Not a question, but a compliment. After refusing a doctor's note last September, advising that my daughter continued to work from home, high-risk conditions and COVID-19, not to mention childcare issue, her employer figured firing her was an acceptable solution. Thanks to Gerlal Claire. Gerlal is one of my partners at our firm. He's a tremendous lawyer. Her case was successfully resolved during mediation. Highly recommended, and thanks. John, really appreciate you sending that note. I will share that with Gerlal. Thank you very much. That's why I tell people you got to contact us. Sometimes you can't get issues resolved on your own. Sometimes the company is going to do things they're not allowed to or supposed to. That's where we come in. All right. So you see the website there, employmentlawyer.ca, to connect, to get in touch, to have that discussion. So please do the same as John Michael and then everyone else. Reach out to me at any time. And now really, there's no reason not to. We're gonna do free consultations right now, moving forward, for people that have lost their jobs, people in that vulnerable situation. They have a right to know what they're owed. They have a right not to be taken advantage of. We're gonna make sure that that's what happens. So reach out to me through employmentlawyer.ca. But that's later. Right now, you still have some time. I'm still here for a little while longer. Ask your question. Post it. Give me a chance to help you. Give me a chance to answer and tell you what you need to know. And in the meantime, I'm waiting for more questions. Let me answer some other questions that I've been getting commonly. Can my employer take away my severance if I don't accept the severance offer? So oftentimes I get asked, well, my employer offered me severance. If I don't accept it, they say I have to sign by Friday. Do I lose something if I don't sign by Friday? So if you ever lost your job, you'll see that in that severance offer, there's a deadline. You have to sign by Friday at 5 or whatever the date is. And that could be very stressful, right? They said I have to sign by Friday or else I don't get it. I better sign. Please don't. That deadline in the severance offer is nothing more than a pressure tactic. That's all it is. It's there to make you fear that you have something to lose, that if you don't sign, you're going to lose something, so that you hurry up and sign. In the vast majority of cases, that severance offer given to you is pennies on the dollar. Pennies on the dollar. So a company may offer you 6 months severance when they owe you 15 months. And can you imagine if you sign that, you walk away from all that additional compensation that you need and that you are legally owed? Don't let that happen to you. You don't lose your legal rights. Your rights don't expire Friday at 5. In fact, you have 2 years to pursue your rights. But once you sign that severance offer, there's no going back. So many people call me after they signed that severance offer, and then a few days or a few weeks later, they realize they made a mistake. They realize they're owed a lot more, and they want to know if I can help them. I can't. If you sign off on that severance offer, even if you're owed another $100,000, that's it. There's no going back. Please don't let that happen to you. Don't let that happen to your friends. Don't let that happen to your family. If you lost your job, you're looking at that severance letter, I know there's a date there. I know it's a pressure tactic. Ignore it. It means nothing. It's a pressure tactic. Give me a call instead. Reach out through employmentlawyer.ca. Let's have a chat. I'm going to continue answering some questions. From Gospel Intel on YouTube, I have a sexual harassment charge, and also became retaliation by texting threats, and witnesses may be had. My mediation coming up on the 30th. I have documents, text messages, and witnesses, and other, etc. So first of all, I really hope that you're not trying to do this mediation on your own without a lawyer. If you do, you will not get a good result. Certainly not as good as what you should be getting, not even close. So right off the bat, if you're planning on going on the 30th to a mediation without a lawyer, huge mistake right there. You need to have a good, experienced, smart, aggressive employment lawyer with you, directing that process, telling you what needs to happen, making sure that the other side knows what they're up against, okay? They're not gonna be afraid of you. They're gonna be afraid of a good lawyer. So that's what you need to do. That's my best advice. If you wanna talk about your case, you wanna strategize, you wanna talk about how much you're owed, let's connect off of social media. Let's have a private chat. You can reach out to me through employmentlawyer.ca. Again, employmentlawyer.ca. But don't try to do this on your own. It doesn't make any sense. Let's see. Jackie says, is there a lawyer on your team in or near Sarnia, Ontario? Jackie, we operate across Ontario. From west to east to north, we're all over it. So my whole team operates across the province. We've done cases in every town, every city, every area of the province. And by the way, also in Alberta and in BC. So do not worry about this. Whether you're in Sarnia, we've done many cases in Sarnia, many, many, many cases. Reach out to me at any time. We'll connect you with myself or one of my team members. The nice thing is you don't have to worry about that geography at all. I mentioned pocketemploymentlawyer.ca. I told you that that's where we have our severance calculator tool. By the way, it's very neat. Maybe you haven't lost your job, but you're curious. Hey, what would I be owed if I did lose my job? Would they have to pay me 6 months? Would they have to pay me 10 months? What is it? Don't wonder anymore. Just go right now. Grab your smartphone and go to pocketemploymentlawyer.ca and find out in seconds how much severance you're actually owed. Very important information to have. Or maybe your friend wants to know how much they're owed. Do tell them to do the same. But there's a lot more that you could do at pocketemploymentlawyer.ca. You can find out if you're an employee or an independent contractor. Remember, a lot of individuals have been misclassified. They believe that they're independent contractors, but they really are employees in the eyes of the law. Happens very often. If you want to know what you are, just go to pocketemploymentlawyer.ca. Maybe your employer let you go and they say, we have just cause to let you go because you did something wrong. If you want to know whether whatever it is that you did rises to the level of just cause, easy. Just go to pocketemploymentlawyer.ca. We have a tool just there for that. If you want to find out if you've been discriminated against, if your matter is considered workplace harassment, that and more, you can do all for free and anonymously on pocketemploymentlawyer.ca. It's like having a lawyer with you at all times. So check it out. Again, it's free, it's anonymous. There's no strings attached, no names to put in, no credit cards numbers to put in. We're using technology here to be able to analyze and advise you on your situation. That's all the time we have for today. I, as always, enjoyed being here. I answered a lot of questions. Happy to talk to you off air. So let's have that discussion. Remember, if you lost your job, if you've been let go from your job for any reason, we're going to do free consultations moving forward to help you in this difficult time understand what you're owed. So don't hesitate. Just go to employmentlawyer.ca to get all the contact information. Don't wait until the next time I'm back on social media. Connect with me today, offline. So go to employmentlawyer.ca. Until next time, I'll be back. Great being here with you. Thank you very much, everyone.